Hi, my name is Andrew Meinzer of Meinzer Law Firm. We take care of people here all across California who are planning to ensure that things go as they want when they die or become unable to take care of themselves anymore. The information that I'm about to provide is based on current California law. It's general information and not specific legal advice. Today, I'll continue to talk with you a bit about your heirs. Your heirs are the people who will receive your assets when you die if you don't do anything to specify the people to receive your assets at that time. This is the third video in an 8-part video series. Again, your heirs are the people who will receive your assets when you die if you haven't specified otherwise. There are many ways to specify the people to receive your assets after your death, and we will talk about that in a later series of videos. If you're married, then your spouse is your primary heir. Again, the same applies to the domestic partners of a registered domestic partnership, and here's how it works. Each spouse essentially owns half of each community property and quasi-community property asset. At the death of the first spouse to die, we'll call that the deceased spouse. The spouse still living, we'll call that the surviving spouse, keeps her half of each community property and quasi-community property asset. That part is simple. The surviving spouse keeps her half. What happens to the deceased spouse's separate property and his half of the community property and quasi-community property? Well, that depends on the other relatives of the deceased spouse that are living at his death. So if the deceased spouse died with no living children, no living grandchildren, no parents, no living siblings, and no living nieces or nephews, in that case, the surviving spouse also receives all of the deceased spouse's half of the community property and quasi-community property. And the surviving spouse receives all of the deceased spouse's separate property. Now, if the deceased spouse died with only one living child, or with no living children, and with the children or grandchildren of only one deceased child, or with one or more living parents, siblings, or nieces or nephews, in that case, the surviving spouse will receive half of the deceased spouse's half of the community property and quasi-community property, and the surviving spouse will receive half of the deceased spouse's separate property. And the third and final scenario is where the deceased spouse dies with 2 or more living children, or with only one living child, and that child has children or grandchildren of more than one deceased child, or with living children or grandchildren of 2 or more deceased children. So again, 2 or more at any of those levels. In this case, the surviving spouse receives 1/3 of the deceased spouse's half of all community property and quasi-community property, and the surviving spouse receives 1/3 of the deceased spouse's separate property. Planning ahead for transfers of assets after your death can be very complicated. There are many factors to consider, including who you want to receive your assets. Also consider how easy you want to make things for your family when you pass away. If you don't do this correctly, you may create confusion, even conflict among your family members after your death. Hiring an attorney experienced with California transfers of assets after death is critical for obtaining the results that you need. In addition, the advice and guidance of an attorney experienced with transfers of assets after death is invaluable in these cases. At Meinzer Law Firm PC, we have over 20 years of experience helping clients with transfers of assets in California. Again, I'm Andrew Meinzer of Meinzer Law Firm. If you know that you need our help with estate planning, transferring assets at death, or even if you just have a question, please contact us and let us take care of you.